What happens when Mickey Mouse swaps his steamboat for a courtroom drama? Well, buckle up, because Disney's century-old mouse just got dragged into one of the strangest legal battles of 2025. A Florida law firm called Morgan & Morgan says it has every right to use Steamboat Willie in a cheeky ad, but Disney, as always, isn't about to give up the wheel without a fight. This class is more than just a quirky lawsuit. It could reshape how we all get to play with public domain icons in the future. So one of the largest firms in America, Morgan & Morgan, decides to grab the spotlight with a bold new ad. Their idea? Pull imagery straight from Steamboat Willie, the cartoon that gave the world its first taste of Mickey Mouse. In their script, Mickey steers his little steamboat but loses control, slamming into Minnie's car. Out pops Minnie, frustrated but resourceful, and who does she call? None other than Morgan & Morgan. The gag plays out like a tongue-in-cheek parody of accident claims, wrapped up with a clear voiceover stating that Disney had nothing to do with the ad. It's cheeky, it's clever, and it taps into a piece of history everyone recognizes. But when they floated the idea past Disney, the House of Mouse didn't exactly chuckle. For Morgan & Morgan, it looked like harmless parody. For Disney, it looked like a potential threat to their most valuable character. And that clash is what set the stage for a lawsuit that could reshape how the public domain actually works in practice. To understand why this battle matters, we need to roll back the film reel to 1928. At that time, Walt Disney was reeling from a huge setback. He had lost Oswald the Lucky Rabbit, his first big hit, to a distributor who claimed the rights. Needing a fresh character fast, Walt and his lead animator Ub Iwerks sketched out a scrappy little rodent. He was originally called Mortimer Mouse, but Walt's wife Lillian thought that sounded too stuffy and suggested something friendlier. Mickey. That name stuck. Mickey's official debut wasn't Steamboat Willie, but when it hit New York's Colony Theater in November 1928, everything changed. Unlike earlier shorts, this one had synchronized sound. The whistles, squeaks, and jaunty score transformed the experience, making the 7-minute cartoon feel like magic. Audiences roared, critics gushed, and Mickey went from sketchpad doodle to national sensation almost overnight. His whistle became more than a tune, it was a symbol of resilience. A little underdog steering through choppy waters. That scrappy charm turned Mickey into not only Disney's mascot, but a cultural touchstone that defined animation for generations to come. Of course, with such a valuable star at the center of their empire, Disney worked tirelessly to keep Mickey locked up under legal protection. Copyright law in the US only lasted so long, but Disney pushed lawmakers again and again to stretch those limits. First came renewals, then the sweeping 1976 Act, and finally the 1998 Sonny Bono Copyright Term Extension Act, so often mocked as the Mickey Mouse Protection Act. Each time, the expiration date for Steamboat Willie moved further into the future. After decades of lobbying, the short finally entered the public domain on January 1st, 2024. But that didn't mean Mickey was suddenly free game. Disney had already lined up a wall of trademarks covering his name, image, and likeness. These protections, unlike copyright, can last indefinitely as long as they're renewed. And Disney has proven it's willing to fight to enforce them. Just this past summer, they sued a jewelry company for selling rings with Steamboat Willie designs, arguing that customers might mistake them for official Disney products. So while the original cartoon is technically public domain, anyone who thinks they can use Mickey without a second thought soon learns that the mouse still bites back. Now cut to January 1st, 2024. After nearly a century under lock and key, the original Steamboat Willie finally slipped into the public domain. But here's the catch. It's not the Mickey you see on lunchboxes today. The only version free to use is the scrappy 1928 sailor, pie-eyed and black and white, without gloves, without color, and without the polished charm that came later. And almost instantly, creators across the internet began testing those waters. Horror filmmakers spun him into a nightmarish stalker and slasher parodies. Indie developers reimagined him as the villain in survival games where the whistle carried a sinister note. Etsy shops filled with mugs, t-shirts, and digital posters showcasing the whistle-happy rodent steering his boat. Even NFT artists grabbed their share of the pie. But freedom came wrapped in conditions. The public can remix and reuse that short film, but they can't make it look like Disney officially signed off. Trademarks keep Mickey's image tied tightly to Disney's identity, If your creation risks making consumers think the company had a hand in it, or worse, tarnishes the brand, then legal action is still on the table. So while the public domain door is technically open, walking through it means tiptoeing past a very alert guard. That reality became crystal clear in the summer of 2025. Morgan & Morgan, the Florida law firm known for its big loud for the people campaigns, saw an opportunity. They wanted to poke fun at accidents in a playful ad using Steamboat Willie's Mickey, but instead of rolling the dice, they sent Disney a letter in July. It politely asked for a covenant not to sue, basically a pinky promise that the mouse wouldn't take them to court. Disney's reply was vague, offering no real assurance. And then, almost immediately after, Disney filed their lawsuit against the Hong Kong jeweler for selling rings inspired by Steamboat Willie. That move sent a chill down Morgan & Morgan's spine. The law firm wasn't about to risk millions on a commercial that might land them in hot water. So in September 2025, they flipped the script and took the fight directly to court. They asked the judge to declare that their ad was fair game, grounded in parody, cushioned with disclaimers, and protected by the fact that the cartoon was already in the public domain. Their argument was simple. No one could confuse their accident parody with an official Disney production. Whether that logic sticks, though, is up to the courts to decide. Disney, true to form, hasn't issued a flashy public statement, but anyone who follows their history knows the playbook. Protect Mickey at all costs, protect the brand halo at all costs. Over the past year alone, they've chased down t-shirt sellers, shut off NFT projects, and slapped lawsuits on indie games that dare to drop Steamboat Mickey into their code. Some of those battles ended in swift victories, others fizzled when judges sided with the creators. Each outcome has only fueled the debate over how much freedom the public domain actually delivers. Legal experts are split down the middle. Some argue trademarks are essential to preserve the integrity of an empire worth hundreds of billions. Others see these lawsuits as corporate overreach that undermines the very concept of the public domain. That's why this case with Morgan & Morgan feels different. It's not about fan art or small Etsy shops. It's a full-scale law firm with resources to fight back, demanding clear boundaries. Many predict this could be the line in the sand. The moment a court decides whether Mickey's public debut truly belongs to everyone, or whether Disney can still cast a long shadow over a century-old whistle. The courtroom clash goes far beyond one cheeky law firm commercial. If Morgan & Morgan comes out on top, it could throw the doors wide open for parodies, bold advertising campaigns, and a wave of creative mashups built on the bones of classic cartoons. Imagine companies reworking old black and white shorts into quirky modern ads, or artists freely remixing century-old icons without fearing a knock from Disney's lawyers. But if Disney secures the win, the message will be loud and clear. Trademarks can outmuscle public domain, keeping a tight grip on characters long after copyright fades away. That would mean anyone hoping to play with these cultural relics would need to think twice, disclaimers or not. And this battle isn't happening in isolation. Other titans are watching closely because more beloved characters are lining up for the public domain spotlight. Popeye's Pipe, Looney Tunes Slapstick, and countless others will soon reach that magical date. How the courts handle Mickey's whistle today could decide whether those future icons belong to everyone, or whether their shadows will remain fenced in by corporate trademarks. The stakes? Nothing less than the shape of tomorrow's creative playground. Nearly a century ago, Walt Disney dreamed up Mickey after losing Oswald the Lucky Rabbit, and that tiny whistle on a steamboat set the foundation for an empire. Now, that same mouse is back in the spotlight. Not on screen, but in court. Testing how tightly Disney can hold on to pieces of culture everyone thought were free at last. From whistle to lawsuit, this mouse never stops making noise. So who's really steering the steamboat now? Disney, Morgan & Morgan, or the public domain? Drop your thoughts below and hit subscribe for more wild stories from the world of cartoons and culture.